Okay, good evening. Okay, let us continue our discussion on Revised Corporation Code of the Philippines. Okay, let us discuss yung content ng Articles of Incorporation. Okay, bali ito yung Section 13 ng RA 11232, which is Section 14 before nung Batas Pambansa bilang 68. Okay, normally hindi nyo tinitingnan yung content ng Article of Incorporation, but this is, for me, this is one of the most important section of the law. Kasi yung Article of Incorporation nagsaserve as contractual relation between the incorporators and the state. Okay, now bali Section 13 yung content ng Article of Incorporation and Section 14 is the form. Okay, yung form sa Section 14, you need to comply it substantially kasi pag hindi nyo kinumply yung form prescribed under Section 14, ground dyan for the disapproval of the Article of Incorporation or its amendment. Okay, now sa content, ang first item na makikita nyo is the name of the corporation. Okay, dapat yung name ng corporation, dapat distinguishable daw siya, okay, from another corporation. Okay, kasi bawal kayong gumamit ng corporate name na not distinguishable from another corporation that is already existing or registered or already reserved. Pero sabi ko nga doon under BP 68 ang ginamit doon is you are not allowed to use a corporate name which are identical, deceptively, or confusingly similar of an existing corporation or those name already protected by law. The second item is the purpose or purposes of the corporation. Okay, now if the corporation has two or more purposes, you need to indicate the primary and the secondary purpose. Now question, pwede ba niyong ilagay dun sa Article of Incorporation, i-combine niyo yung primary and secondary? The answer is no. Kasi very specific ang batas na kapag may two or more purposes kayo, you need to indicate the primary and the secondary purpose. Now, okay, provided that a non-stock corporation may not include a purpose which would change or contradict its nature as such. Kasi di ba ang nature ng non-stock, in organization not for profit, in organization for charitable, cultural, fraternal, okay, scientific, literary, and so on. Kaya naman nilagay nyo dun sa purpose ng non-stock corporation, ang purpose ninyo is mag-generate ng profit. Okay, that is not allowed. Okay, kasi bawal kayong mag-indicate ng purpose na i-contradict nyo, okay, or i-change yung nature ng non-stock corporation. Okay, now question, why is it that the purpose is important? Okay, kasi take note, under the law kasi, pag ang purpose or purposes ng corporation is patently unconstitutional, illegal, immoral, or contrary to existing government rules and regulation, ground na naman siya for the disapproval of the Article of Incorporation or its amendment. Kaya pagtingin pa lang ng SEC, nakita doon na ang purpose nyo pala, patently unlawful, then okay, denied kaagad ang inyong i-deny yung inyong Article of Incorporation. Okay, next. Okay, another classical reason kung bakit naka-specify dapat yung purpose. Kasi para ma-determine of course ng public, in general, yun bang corporation is, they are acting within the power conferred. Kasi remember, di ba, ang powers lang na pwedeng i-exercise ng corporation is only express, implied, saka incidental power. Yung express powers kasi, walang problema eh. Kasi nakalagay yan sa law. Okay? Tapos, okay, nakalagay doon sa batas yan. Okay, pero ang problema yung implied. Kasi lahat ng act ng corporation na reasonably necessary para ma-attain nila yung purpose na naka-indicate sa Article of Incorporation, that is an implied exercise of implied power. And therefore, hindi siya ultra vires act. That's why how can the public know whether or not the corporation is acting within the power conferred kung hindi niya lalagay yung purpose dun sa Article of Incorporation? Now, the place where the principal office of the corporation is located, which must be within the Philippines. Pero by the way, dapat ilagay nyo dito yung city or municipality where the principal place of business is located. In fact, under Memorandum Circular issued by the SEC, kailangan nyo nakalagay ang specific address. Okay, kung nakalagay yan sa building, dapat nakalagay yung building name, yung unit number. Okay, tapos yung street as well as yung barangay and city and municipality. Now, the term for which the corporation to exist if the corporation has not elected perpetual existence. Now, under BP 68, di ba, ang maximum period or term that may be stated in the article is only 50 years. Pero under the Revised Corporation Code of the Philippines, which is RA 11232, okay, kapag wala kayong in-indicate na period or term sa article of incorporation, automatic it is perpetual life. Pero kung gusto nyo maglagay ng period, walang problem. Okay, pero pwede na kayo maglagay ng any period. Okay, wala na siyang limit of 50 years. In fact, kung ayaw nyo maglagay, pwede nyo i-indicate na wala na lang na period, automatic perpetual life siya. Now, the names, nationality, and residence address of the incorporators. Okay, kaya lalagay nyo din yung names, okay, yung nationalities, and residence of the incorporators. Okay, now dati, yung names dito, di ba? Makikita kasi halimbawa kung corporation partnership, okay, di reject agad yung article niya. Okay, papa-modify kagad siya. Kasi ba under BP 68, 'di ba, before bawal ang partnership and corporation. Pero okay, of course under RA 11232, any person na. Tapos nakalagay siyempre yung kanilang respective nationality. Okay, and residence address. Tapos the number of director which shall not be more than 15. Kasi dati before sa BP 68, ang numbers of director is not less than 5 but not more than 15. Pero dito sa RA 11232 nakalagay not more than 15. Kaya lumalabas minimum of 2, maximum of 15. I repeat, yung 1 refers to one-person corporation or the OPC. Pero take note, in case of a non-stock corporation with respect to the Board of Trustees, the numbers is more than 15. Maybe more than 15. Next, the name, nationalities, and residence address of person who shall act as a director or trustee until the first regular directors or trustees are elected. Okay, and qualified in accordance with this code. Okay. Content daw ng Article of Incorporation, paragraph H is a stock corporation, dapat nakalagay dito yung amount ng authorized capital stock, the number of shares, okay, divided into, okay, and the pertinent par value. Tapos nakalagay din yung names, nationality, and residence ng original subscriber, the amount subscribed, and the amount paid up. Okay, now dito dati importante yan para ma-determine dito, okay, kung na-comply ba yung section 12 ng BP 68 na at least 25% of the authorized capital stock must be subscribed and at least 25% of the total subscription must be paid, but in no case should the paid up capital be less than 5,000. Pero by the way, under section 13, okay, of Republic Act 11232, okay, lumalabas, okay, sorry, section 12 na siya kasi yung section 13 wala na eh. Okay, nawala yun sa RA 11232. Yun yung section 13 ng BP 68. Kaya lumalabas, wala na tayong minimum paid up capital requirement subject only to the provision under special laws. Now, kung non-stock corporation, the amount of its capital, the names, nationality, and residence address of the contributors, the amount contributed by each, and of course, pwede ka mag-plugin ng such other matters daw. Basta ang kailangan lang consistent siya with law, which the incorporators may deem necessary daw and convenient. Kasi hindi naman kayo pwede maglagay ng provision under the article na okay, prohibited by law. Kasi ba, nag-create kayo for instance ng founder shares, tapos bibigyan nyo ng exclusive right to vote and be voted for a period of 10 years, that is not allowed. Because it will conflict the provision under the law. Okay, now, take note that you may likewise provide in the Article of Incorporation regarding arbitration agreement. Okay, in fact, under the law, pwede nyo ilagay sa Article of Incorporation, pwede nyo ilagay sa bylaws, or such other document. Okay, ano ba yung purpose ng arbitration agreement? Okay, alam naman natin na yung mga court, okay, sa court, sobrang dami ng kaso. Okay, meaning para ma-unclog yung court docket, better na maglagay kayo ng provision for arbitration agreement. Para in case nagkaroon ng conflict among the stockholders and okay, corporate directors, okay, then hindi kayo kaagad didiretso sa court. Okay, kailangan nyo munang idaan sa voluntary arbitration. Okay, kaya sabi dyan, an arbitration agreement may be provided in the Article of Incorporation pursuant to Section 181 of this code. Kasi in fact, they are encouraging arbitration, yung voluntary arbitration para ma-unclog yung court docket. Pero by the way, hindi lang siya limited sa article. Pwede mo siyang ilagay sa Article of Incorporation, sa bylaws, or such other document. Okay, now, filing of Article of Incorporation, you can either file it through personal filing or electronic filing in accordance with Commission's rules and regulation. Okay, hindi ko lang alam kung fully operational na yung electronic filing. Okay, parang I think na-start na itong electronic filing nila. Kaya pwede kayo mag-file, okay, through personal, go before the SEC, or through submission, okay, through electronic filing. Now, okay, isa-isahin natin yung item ng Articles of Incorporation. First item is the name of the corporation. Okay, dapat ang extension word ng corporation must be Corp, Inc, or Incorporation, or OPC, or one-person corporation in case of one-person corporation. Dapat meron kayong extension na OPC. Okay, sabi ko before sa BP68, bawal kayong gumamit ng corporate name na identical, deceptively, or confusingly similar of an existing corporation or those name already protected by law, or patently confusing or contrary to law. Ngayon, pag tiningnan nyo yung comparison niya, yun nga, di ba binanggit ko, bawal yung identical, deceptively, confusingly similar, to that of existing corporation or to any other name already protected by law, or patently deceptive, confusing, or contrary to existing law. Sa Section 17 ngayon ng RA 11232, binago yung term, nakalagay dyan, not distinguishable. Kasi bawal kayong gumamit ng corporate name na not distinguishable, okay, from that already reserved. Take note, nakalagay dyan, reserve pa lang. Kasi halimbawa, pina-reserve na kunwari yan, yung corporate name, di mo na pwedeng gamitin. O kaya, naka-registered na talaga. Sabihin, registered na yung corporate name before the SEC. Okay, or for the use of another corporation. O kaya yung such name daw is already protected by law. Okay, almost the same yan dito. Or when its use is contrary to existing laws, rules, and regulations. Ngayon, dinefine dito class, ano ba ibig sabihin na not distinguishable? Sabi niya, a name daw is not distinguishable even is contain one or more of the following. Okay, halimbawa, gumamit kayo ng corporation. Bawa, may existing San Miguel Corporation, ginawa mo San Miguel Company. Hindi yun considered as distinguishable kasi sabi ko corporation yung isa company. Kaya San Miguel Incorporated. Okay, or naglagay ka ng limited or limited liability or abbreviation of one of such word. Kaya naglagay ka ng punctuation, articles, conjunction, contraction, preposition, abbreviation, different tenses, spacing, or number of same word or phrase. Kaya kahit gamitin mo yan, consider yan as not distinguishable from another corporation and therefore your proposed corporate name may be denied. Ngayon, okay, ito yung mga violation. Okay ha, yun nga, not distinguishable from a name already reserved or registered for the use of another corporation, already protected by law, or contrary to law, rules, and regulations. Ngayon, what if ganito? Yung proposed corporate name nyo pala, registered na. Okay? Ngayon, pag may nag-file for instance ng complaint dyan, okay, then the SEC may summary order. Take note, summary yan. Okay, yung the SEC may summary order the corporation to immediately cease and desist, meaning you are now prohibited to use that, okay, corporate name. Ngayon, anong legal effect? Okay, ito meron siyang corresponding penalty pursuant to Section 159. Fine ranging from 10,000 to 200,000 pesos. Okay, yan yung for use of unauthorized use of corporate name. Ngayon, take note that if the corporation refuse to comply the cease and desist order, okay, issued by the SEC, ito ang epekto niya. Okay, pag di nyo kinomply ha yung cease and desist order ng commission. Una, pwede kang i-held in contempt. Okay, meaning yung corporation and its responsible directors, officers may be held in contempt. Tapos nakalagay and or. Kaya ibig sabihin pwedeng magkasama yan. Okay, hold them administrative, civilly, and criminally liable. And or again, revoke the registration of the corporation. Kaya pwedeng ang gawin ng SEC sabay-sabay yan kasi nakalagay dyan and or. Kaya may contempt na yung corporation as well as the directors and responsible officers. Second, meron pang criminal, civil, and administrative case. And another is revoke the registration of the corporation. Okay, ngayon, kaya ang gagawin nyo, di ba normally kasi pag file nyo for instance ng article of incorporation, may undertaking kasi dito yung corporation na in case may gumagamit na nung inyong proposed corporate name, you're undertake to change your corporate name. Ngayon, pag nag-change ka ng corporate name, mag-a-amend kayo ng article. At pag ang amendment ng article for change of corporate name is approved by the SEC, then the SEC will issue another certificate of incorporation under the amended name. Now, take note that the commission thou shall also cause the removal of all visible signage. Kasi halimbawa may mamaya, yung corporation pala naggawa na ng Facebook page, okay, or gumawa na ng website. Okay, ginagamit nila yung corporate name na not distinguishable from another corporation na registered na pala. In that case, okay, o kaya may mga signage na kayo, may mga advertisement, okay, may labels, may prints, then pwede siyang ipa-remove ng SEC. And I repeat, okay, once the SEC issued a cease and desist order, okay, na wag nyo nang gamitin yung corporate name na yan, ito yung corresponding penalty. Balikan nyo ha, contempt, criminal, civil, and administrative cases, okay, as well as, okay, revocation of the registration. Now, change of corporate name does not result in creation of another corporation. Kung baka pag nag-amend ka ng article of incorporation for change ng corporate name, okay, there is no another corporation created. Okay? Walang makikreate na new corporation and therefore it will not give you additional right nor impose additional obligation. Kumbaga change of designation lang. Now, corporate names of education institution containing the word lyceum. Yung term lyceum kasi, generic yan eh. Means educational institution. Kaya wala kang exclusive right na gamitin yung word lyceum. Now, under the General Banking Act, bawal yung gamitin yung extension word na bank, banking, banker, building and loan association if you are not a bank. Okay. Now, otherwise, mako-confuse of course yung public. Under the Rural Bank Act, bawal yung gamitin yung extension word na rural bank. Under Act 2612, it prohibit the word national for business of bankers, brokers, or saving institutions. Under RA 226, bawal kayong gumamit ng emblems, official seal, and name ng United Nations. And under RA 247, you are not allowed to use the extension word bandit if you are not engaged in warehouse business. Okay, letter B or second item do sa article of incorporation is the specific purpose or purposes ng corporation. Now, sabi ko kapag ang corporation ay may two or more purposes, you need to indicate the primary and secondary purpose. Pero hindi nyo pwedeng indicate dito, okay, sa non-stock corporation yung purpose na it will contradict its nature as such. Number 3 is the place where the principal office of the corporation is located, which must be within the Philippines. Hindi nyo naman pwedeng ilagay dito sa article nyo na the principal office of the corporation is located anywhere in the Philippines. Okay? Okay, lagay mo the principal office of the corporation is located in Makati City. Okay, before kasi, pwede yan. Dati. Okay, pero nag-issue na ang SEC ng Memorandum Circular number 3-2006 na nire-required na dapat i-indicate nyo yung street number, street name, barangay, city, or municipality. Okay, kaya yung city or municipality, lalagay mo lang Makati City, o kaya City of Manila, Quezon City, or Metro Manila is no longer allowed as address of principal office. Pero take note that yung mga corporation na naka-registered na ang naka-indicate pa ring address is Metro Manila, Makati City, okay, Quezon City, they are not required to amend their article to reflect the complete address. Ang problema, okay, in 2014, yan yung SEC Memorandum Circular number 2006 ha. Ito naman yung SEC Memorandum Circular number 2014 na dinidirect lahat ng corporation na mag-amend. Okay, ibig sabihin kung ang nakalagay sa Article of Incorporation nyo na address is still Metro Manila, Makati, okay, City of Manila or Quezon City lang. Now, required kayong mag-amend ngayon ng Article of Incorporation to indicate the complete address. Pero okay, ang deadline is until December 31, 2014. Pero ang question, what if hindi kayo nakapag-comply within that period? Sabi ng circular na to, wala namang effect. Okay, wala namang penalty. Pero magkaka-problem kayo. Kung meron kayong mga pending certification or pending amendment, then i-defer ang release. Kaya sabi ng Section 4 ng SEC Memorandum Circular number 6, no penalty or for non-compliance within the time prescribed until December 31, 2014. Pero sabi yan, the Commission daw can impose the sanction of deferment of applications such as amendment, certifications, and clearances, and the like. Now, letter D, the term for which the corporation is to exist if the corporation has not elected perpetual existence. I repeat, if you look Batas Pambansa Bilang 68, the maximum period or term that may be indicated in the Article of Incorporation is only 50 years. Okay? Kaya kung maglalagay ka ng 60, okay, i-reject yan. Ngayon, pwede na kayo maglagay ng 60 years. Okay, pero take note, if you fail to indicate therein the term, then automatic the corporation has a perpetual life. Ngayon, okay, automatic a perpetual life kung walang naka-indicate sa Article of Incorporation. Now, ang question dito class is this. What if create kang corporation under BP 68? Siyempre yung okay, certificate of incorporation nyo na issue prior to effectivity of Republic Act 11232. Okay, meaning prior to February 23, 2019. Okay? Ngayon, ang sabi ng batas, ang problema, nung February 23, 2019, okay, and onward, covered ka na ng RA 11232, wherein meron ng perpetual life. Now, under the law, automatic yan. Ibig sabihin, lahat ng mga corporation na meron ng Certificate of Incorporation prior to effectivity of RA 11232, automatic perpetual life siya. Okay? Kaya ibig sabihin, yung halimbawa, nakalagay mong terms doon dati is 50 years, automatic perpetual life ka ngayon. Ngayon, if the corporation decide for instance to maintain its term, okay, gusto niyang i-maintain yung period na nakalagay sa article, kailangan niyong i-notify yung commission. At kailangan ng vote ng majority of the outstanding capital stock. Paki-check niyo yung voting requirements dito kasi napakalaki ng probability na itatanong yan sa board exam. Kaya may requirement kung gusto nyong i-maintain. Okay, kung kayo ay corporation na na-issuehan na ng Certificate of Incorporation prior to effectivity of RA 11232, if you want to maintain the period indicated in the article, you need to notify the SEC. And of course, it requires approval or vote of majority of the outstanding capital stock. Okay, now, How about, what if the corporation term expired? Bawa, naglagay ka ng period sa article of incorporation na 50 years and nag-expired siya this year. Okay, under batas pambansa bilang 68 kasi before, di ba? Pag nag-expired yung corporate term, okay, patay yung corporation dyan. Pero, okay, meron tayong tinatawag na 3 years extended life, right? Alam niyo naman siguro yun, may 3 years extended life. Pero not for purpose of continuing business, but only for purpose of liquidation. Kaya hindi na kayo pwedeng mag-amend pa ng article for the extension of corporate terms in that case. That is prior to BP6, that is prior to RA 11232 kasi under BP 68. Eh ang problema, kung nag-expired ka ngayon, okay, starting February 23, 2019 and onward, okay, meron na tayong tinatawag na revival ng corporation, which is wala yan before under BP 68. Kaya halimbawa, nag-expired ang term mo ngayon. Okay, parang technically is patay yung corporation. Pero pwede kayong mag-file ng petition for revival before the Security and Exchange Commission. At once na in-approve ng SEC yung petition for revival, automatic perpetual life siya. Unless na naman, okay, in-indicate nyo dun sa petition na gusto nyo lang ng, okay, may period or term. Pero once na walang nakalagay na term sa petition for revival, automatic perpetual life siya. Okay? Ngayon, by the way, may requirement under the law. Okay, na kapag may mga corporation class na before they can file a petition for revival, before the Securities and Exchange Commission, kailangan nyo ng favorable recommendation coming from the appropriate government agency. Kabawa, bangko yan. Bank, dapat meron niyang favorable recommendation coming from Bangko Sentral. Premids, Insurance Commission, ganon din sa insurance companies, trust companies, banking and quasi-banking institution, pawn shop, yan, puro sa bangko yan. Corporation engaged, central bank halos lahat. Corporation engaged in money service business, other financial intermediaries, saka non-stock saving and loan association. Kaya ibig sabihin, bago kayo okay makapag-file ng petition for revival, kailangan meron kayong favorable recommendation coming from the appropriate government agency. Okay, now, ang lumalabas na mnemonic natin is BPITB, Bank Public, okay? Hindi na ito public utilities, bali, okay, kasi di ba yung BPITB sa ano yun, ito yung mga corporation na prohibited mag-issue ng NOPAR. Palitan mo yung P dyan, hindi public utility yan. Okay, that is pawn shop, okay? Ito naman tama, insurance company, trust company, okay? Tapos ito, instead na building and loan association, gawin mong banking and quasi-banking institution. Okay, tapos ito is pre-need company. Okay, corporation engaged in money service business, other financial intermediaries, and NSSLA, non-stock savings and loan association. Now, okay, based on Section 1 of Memorandum Circular Number 23-2019, dated November 21, 2019, okay, the following corporation may file a petition for revival of corporate existence. Okay, letter A, generally a corporation whose term has expired. Kaya kung nag-expired yung term mo, okay, simulang February 23, 2019 onward, okay, you can file a petition for revival. Pangalawa, na expired corporation whose certificate of registration has been revoked. Okay, ibig sabihin ni-revoke na yung certificate of registration. For non-filing of report, mga di ka nagpa-file ng GIS, audited financial statement, provided that it shall file the report, okay, proper petition to lift its revoked status, which may be incorporated in its petition to revive, and must settle the corresponding penalties thereof. Another is expired corporation whose certificate of registration has been suspended, provided it shall file the proper petition to leave its suspended status, which may be incorporated in its petition to revive, and must settle the corresponding penalties thereof. Or letter D, an expired corporation whose corporate name has already been validly reused and currently being used by another existing corporation duly registered with a commission provided that the former shall change its corporate name within 30 days from the issuance of certificate of revival of corporate existence. Now, sino ba yung hindi naman pwedeng mag-file ng petition for revival? Okay, hindi kayo pwedeng mag-apply ng revival. Okay, A, an expired corporation which has completed the liquidation of its asset. Kasi may nag-expired na, tapos nakapag-liquidate na. Letter B, a corporation whose certificate of registration has been revoked for reason other than non-filing of report. Okay? Another corporation dissolved by virtue of Section 6C and 6D of PD number 902-A. Ano ba yung PD 902-A? Ito yung act creating the Security and Exchange Commission. Okay, as amended by PD number 1799. An expired corporation which already availed of registration in accordance with Memorandum Circular number 13, series of 2019. Amended guidelines and procedures on the use of corporate and partnership names or other memorandum circulars issued by the Commission pertaining to registration except when number 1, the registered corporation has given its consent to the petitioner to use its corporate name and has undertaken to undergo voluntary dissolution immediately after the issuance of petitioner's certificate of revival. And number 2, the registered corporation has given its consent to the petitioner to use its corporate name and has undertaken to change its corporate name immediately after the issuance of the petitioner's certificate of revival. Now, meron akong question. Okay, wala kasing binanggit dito sa circular. What if nag-expired ang term ng corporation prior to effectivity of RA 11232? Kasi walang issue kung nag-expired yung term mo after effectivity of RA 11232. Wala namang binanggit dito sa memorandum circular. Okay, in that case, kung nag-expired yung term ng corporation prior to February 23, 2019, then hindi ka pwedeng mag-file ng petition for revival because wala pang existing law that allow you to file a petition for revival. Non-existing law pa siya. At walang nakalagay na provision under RA 11232 regarding retroactive effect. Kaya dapat nag-expired siya after effectivity of the law. Okay, ito yung lumalabas na mag-a-apply na memorandum circular. Now, may required vote tayo pagdating sa petition for revival. Kailangan ng majority vote ng Board of Directors, and vote of at least majority of the outstanding capital stock. Kung ito naman ay non-stock corporation, is majority ng Board of Trustees and majority of the members. Okay, saan kayo magfa-file ng petition for revival? Okay, ng corporate existence. Okay, pwede nyo siyang i-file syempre sa SEC. Okay, either sa Commissions, Companies Registration and Monitoring Department or CRMD, or pangalawa, any SEC satellite office or any SEC extension office daw. Okay, now meron tong payment of fees of course. Kailangan nyo magbayad ng petition fee amounting to 3,060 inclusive of legal research fees and documentary stamp tax. Now, filing fee for the extension of term of existence based on present authorized capital stock of the company for the stock corporation pursuant to SEC Memorandum Circular number 3, series of 2017. Okay, consolidated, scheduled fees and charges or other amendment thereto. Okay, now punta tayo doon sa grounds where the article of incorporation or amendment to be disapproved. Now, by the way, class, paki-check niyo yung provision sa BP 68. Nakalagay doon is grounds when the article of incorporation may be rejected or disapproved is amendment. Tapos dito ang wording na nakalagay, grounds where article of incorporation or amendment may be disapproved. Nawala na yung word reject. Kasi dati, grounds when the article of incorporation may be rejected. I-reject yung article of incorporation or disapproval of its amendment. Bakit nawala na yung word reject? I think mas accurate kasing gamitin yung word disapprove rather than reject. Okay, ano ba pinagkaiba ng reject sa disapprove? Maliban sa parehas silang masakit. Okay? Kasi pag sinabing reject, di ba? Parang totally, parang reject. Wala mang maayos kahit isa. Pero pag sinabi kasing disapprove, okay, hindi naman totally reject yung entire eh. May specific portion lang, okay, na hindi okay or simply disapprove. Okay, kasi pag sinabi mong reject, parang total eh, di ba? Kaya instead na ginamit yung word reject, ginawa na lang disapprove. Kaya lumalabas dito, ito yung grounds natin for the disapproval ng article of incorporation, okay, or okay, is amendment. In fact, okay, if you read the provision under the law, nakalagay din kasi dyan na bibigyan ng SEC, okay, ang okay, applicant, which is the incorporators, na i-change yung mga objectionable portion sa article of incorporation as part of the due process. Kaya dapat hindi siya totally rejected. Okay, yung may okay, kasi may mga item lang na specific item in the article, okay, na hindi siya in accordance with the requirement set forth by the SEC, by law. Kaya disapprove lang. Kaya sabi dyan, ito yung grounds natin ha. Number 1, that the article of incorporation or amendment thereto is not substantially in accordance with the form prescribed therein. Kaya tandaan nyo ha, yung section 13, yan yung content ng article. Yung section 14 is form ng article sa RA 11232. Kaya dapat i-comply nyo yung form prescribed ng article. Kasi pag hindi nyo kinomply substantially yung form prescribed ng article of incorporation, that is a ground for the okay, disapproval of the article of incorporation or its amendment. Second is the purpose or purposes of the corporation is patently unconstitutional, illegal, immoral, or contrary to existing government rules and regulation. Okay, makikita mo yan sa second paragraph ng article, di ba yung purpose? Tapos number 3, the certification concerning the amount of capital stock subscribed and or paid is false. Before kasi sa BP 68, ang nakalagay dyan is that the treasurer's affidavit. Pero under RA 11232, instead na treasurer's affidavit, ginawa na lang siyang certification. Okay? Kasi wala nang requirement ng treasurer's affidavit. Okay? Binago lang yung term, di ba? Lumalabas treasurer certification. Isa-certify kasi ng corporate treasurer na okay, ito yung lumalabas na authorized, ito yung amount sinubscribe at ito yung amount paid up. Pero walang requirement doon sa 25% rule kasi deleted na yung section 13 o Batas Pambansa bilang 68. And of course, the number 4, ito applicable lang to sa mga nationalized corporation. That the required percentage of Filipino ownership of capital stock under existing laws or the Constitution has not been complied with. Kaya hindi na comply, okay, yung percentage requirement, okay, required by law. Now, okay, ito yung sinabi ko sa inyo class na part ng due process. That the commission shall give the incorporators, directors, or officers a reasonable time, okay, from receipt of this approval within which to modify the objectionable portion of the articles or amendment. Kaya bibigyan kayo ng chance or bibigyan kayo ng reasonable period ng SEC para i-amend. Okay? I-modify yung mga specific objectionable portion doon sa article of incorporation or its amendment. Now, okay, now paki-check nyo nga to. Lagyan lang natin ng konting comparison. Sabi ko sa inyo, examiner, okay, mahilig siya dun sa changes from BP 68 papunta doon sa RA 11232. Sa Batas Pambansa bilang 68, naka-enumerate doon yung mga corporation na kailangan ng favorable recommendation coming from the appropriate government agency when filing an article of incorporation before the SEC. Nakalagay dyan is bank, banking and quasi-banking institutions, trust companies, other financial intermediaries, insurance companies, building and loan association, public utilities, educational institution, other corporation governed by special law. Ang problema, pag kinompare mo siya sa RA 11232, nawawala na tong mga to. Wala na yung Building and Loan Association, public utilities, educational institution, other corporation governed by special law. Pero dun sa RA 11232, dinagdag yung pre-need companies, non-stock saving and loans association, saka yung pawn shop. Siyempre yung issue ngayon or question ngayon dito is this. Dati kung ikaw ay school, kailangan mo ng favorable recommendation coming from the CHED or DepEd. Pero based on sa RA 11232, dinilit siya. Hindi mo na makikita sa enumeration yung educational institution, mga public utilities, saka yung building and loan association. Normally, ang mga lumabas dito or na-include ngayon dito sa RA 11232, yan yung mga corporation na nagkakaroon ng borrowing, okay, from the public. Okay? Di ba? Nagkukuha kayo ng fund from the public, katulad ng mga pre-need companies, di ba? Okay, non-stock and saving association, pawn shop, mga bangko, okay? Pero ito dinilit na. Okay? Ngayon, ito hindi dapat itanong sa CPA board exam to. Kasi mga covered to ng special laws actually. Okay, pero by the way, paki-check nyo na lang. Ito, kailangan 100% Filipino. Ito yung tinatawag na 100% nationalized corporation. Meaning foreign nationals are not allowed. Mass media, okay, practice of profession, retail trade enterprises with paid up capital of less than 2.5 million US dollars. Private security agencies, small-scale mining, utilization of marine resources in archipelagic water, territorial sea, and exclusive economic zone, as well as small-scale utilization of natural resources in rivers, lakes, bays, and lagoons, ownership, operation, and management of cockpits, manufacture of firecrackers, and other pyrotechnic devices. Ito naman yung partially owned, partially nationalized corporation. Okay, 75% Filipino is private radio communication network, private recruitment, whether for local or overseas recruitment, contract for the construction and repair of locally funded public works, contract for the construction of defense-related structures. 70% Filipino is pawn shop business. Okay, business activity of advertising. Ito naman 60% Filipino. Okay, ang dami niyan, di ba? Okay, exploration, development and utilization of natural resources, ownership of private lands, operation of public utilities, education institution other than those established by religious groups and mission boards, culture, production, milling, processing, trading, except retailing of rice and corn and acquiring by barter, purchase or otherwise rice and corn and the byproduct thereof, contract for the supply of materials, goods, and commodities to government-owned or controlled corporation, company, agency, or municipality. Facility operator of an infrastructure or development facilities requiring a public utility franchise, operation of deep-sea commercial fishing vessel, adjustment companies, ownership of condominium units, manufacture, repair, storage, and or distribution of products and or ingredients, requiring Philippine National Police clearance, manufacture, repair, storage, and or distribution of product requiring Department of National Defense clearance, manufacture and distribution of dangerous drugs, sauna and steam bath houses, massage clinic, and like other activities regulated by law because of risk posed to public health and morals. Domestic market enterprises with paid-in equity capital of less than the equivalent of 200,000 US dollars. Domestic market enterprises which involve advanced technology or employ at least 50 direct employees with paid-in equity capital or less than equivalent of 100,000 US dollars. Partial nationalized corporation pa rin, 40% financing companies, investment loans. Pero sabi ko sa inyo, hindi yan dapat itanong sa board exam. Masyado ng... Kasi bawat item na nakikita nyo dyan, naki-scattered provision yan sa different laws as well as constitution. Okay? Basta kailangan alam nyo lang na may tinatawag tayong nationalized corporation. Okay? At dapat i-maintain nyo yung percentage of ownership to be owned by the public, otherwise ground dyan for the disapproval of the article of incorporation or its amendment. Ngayon, doon sa minimum paid-up capital requirement, sabi ko nga sa BP 68, sabi dyan, parehas lang yan, BP 68 and RA 11232, stock corporation shall not be required to have a minimum capital stock except as otherwise specifically provided by special law. Pero pag binasa mo yung BP 68, may nakalagay na subject to the provision of special law and subject to the following, okay, subsequent articles, na section. Eh, ang problema, doon sa section 30, may nakalagay na at least 25% of the authorized capital stock must be subscribed and at least 25% ng total subscription must be paid, but in no case should the paid up capital be less than 5,000 pesos. Okay, however, if we look section 14 of section 12 of Republic Act 11232, okay, nawawala na dito yung section 13. Okay? Na wala nang section 13 ng BP 68. Di mo na siya makikita sa RA 11232. Kaya ang intention ng lawmaker dito is wala na tayong 25% rule. Okay? Now, kaya yan na, alam niyo na yan, familiar na kayo dyan before pa. Okay, ginagamit nyo rin yan sa accounting. Ngayon, meron tayong mga minimum paid up capital requirement, okay, that are subject to special laws. Kaya pag tiningnan mo yung website ng SEC, okay, makikita nyo rin to yung banks kunwari, pero may nakalagay dyan, please refer to BSP guidelines. Bakit? Kasi maraming klaseng bangko, magkakaiba rin yung kanilang minimum paid up capital requirement. Siyempre, iba yung requirement for commercial bank, iba yung universal bank, iba yung rural bank, iba rin yung lumalabas na savings bank, thrift bank, and so on. Break bulk agent is 250,000, cargo consolidator 200,000, financing company head office, okay, pag Metro Manila and other first class cities, 10 million, other classes of cities, 5 million, municipalities, 2.5 million, foreign branch office, 200,000 US dollar, foreign representative, okay, office is 30,000 US dollar, freight forwarders, 300,000, foundations, non-stock corporation, 100,000 working capital, health maintenance organization, 10 million, insurance company, nakalagay dyan, please refer to Department of Finance Order number 194 dated this October 24, 1996. Kasi marami rin ang insurance company, iba-iba rin yung kanilang different paid up capital requirement. Investment advisor manager is 10 million, investment company is 50 million, investment house is 300 million. Pero by the way, hindi kayo required na kabisaduhin yung mga minimum paid up capital requirements, okay, required for special corporation or okay, or mga ano yan, mga corporation governed by special laws. Okay, yan, iba pa rin to, minings. Please refer to Department of okay, Department of Environment and Natural Resources Memorandum Order number 99-10. Okay, 500,000 for non-vessel operating common care, pawn shop 100,000, pre-need, okay, 100 million. Pre-need plan agent 5 million, recruitment agency for overseas employment 1 million, reinsurance company. Okay, meron na namang referral sa Department of Finance, okay, Finance Order number 100-94. Retail trade activities with foreign equity, 2.5 million US dollar. School, elementary education, 1 million. Elementary and secondary education is 2.5 million. Elementary, secondary, tertiary, postgraduate education is 5 million. Security agency is 500,000. Security broker dealer, okay, 100 million. Security broker dealer, non-existing SRO members, 5 million. Security broker dealer and proprietary shares non-SRO members is 5 million. Okay, dami pa niyan. Hindi yan tatanong sa board exam. Okay? Kasi mga ano yun, mga subject to special laws. Pinakita ko lang sa inyo. Basta ang kailangan alam nyo lang na may tinatawag tayong mga corporation, okay, na may minimum paid up capital requirement subject to the provision of special laws. By the way, ito, old question to. Okay? Bawa, 1 million yung authorized. 250. 25%, 25%. Di okay yan. Pangalawa, 100,000 times 25% times 25%, 6,250. Okay yan. 50,000 times 0.25, 12,500 times 0.25, that is 3,125 na. Hindi na pwede. Kaya dapat minimum 5. 10,000 times 0.25 is 2,500, hindi pwede. It should be 5,000 dapat. Times 0.25, 1,250, should be 5,000. Kaya kung 5,000 yan, 5,000, 5,000, okay, na-comply ko yung provision ng section 13. Pero sabi ko nga, may parang merong naitanong yata before daw sa board exam na okay, hindi ko sure kung tinanong talaga. Okay, parang ang pagkaka-formulate siguro baka ganito. Okay, alin dyan yung i-approve if any kung meron kayong nakitang ganitong question. Okay, ang problema ang question kunwari is no par. Pagtingin mo initially, it seems that there is no answer. Kasi mukhang okay lahat doon sa 25-25% rule. Pero by the way, since the question is no par, the answer should be yung number 3. Okay, yung third. Bakit? Kasi yung sinubscribe, fully paid siya. Kasi nare-recall niya ba yung distinction between par and no par? Sabi ko, ang isang distinction between par and no par, pagdating sa no par value shares, once issued, these are deemed fully paid and therefore non-assessable. Kaya dapat pag sinubscribe, fully paid siya. Ito kasi, hindi naman siya fully paid. Okay, kaya paki-check nyo. Pero by the way, hindi natatanong syempre sa board exam yan kasi wala na tayong 25% rule. Now, let us proceed now sa section 18. Sabi dyan, a private corporation form organized under this code commences to have corporate existence and juridical personality and is deemed incorporated. From the date the SEC issues a certificate of incorporation under its official seal. And thereupon, the incorporators, stockholders, members, and their successors shall constitute a body politic and incorporate under the name stated in the article of incorporation for the period of time mentioned therein, unless said period extended or corporation is sooner dissolved in accordance with law. Now, before, laging tinatanong sa board exam yan, section 18 ng RA 11232 na dating section 19 of Batas Pambansa bilang 68. Ang laging tanong lang dun is, kailan daw magko-commence ang legal personality ng private corporation organized under this code? Siyempre, ang sagot mo lang is from the time of the issuance ng certificate of incorporation by the SEC under its official seal. Walang kwentang tanong, di ba? Now, let us modify. Ang unang question ko is section 18 applicable to a public corporation? Of course, the answer is no. Kasi ang sabi niyan, private corporation. Okay? Nakalagay dyan, private corporation. Kaya hindi siya mag-a-apply sa nakalagay private corporation, hindi mag-a-apply sa public. Next question, mag-a-apply ba ang section 18 sa mga government-owned and controlled corporation? The answer is no. Because normally government-owned and controlled corporations are not organized under this code, but rather they are created by a special law. And therefore, they are primarily governed by the law creating them. Okay, next question, is section 18 applicable to a foreign corporation? Of course, the answer again is no, because these are not organized, foreign corporations are not organized under this code because these are organized under foreign law. Another is section 18 applicable to a sole corporation. The answer again is no. Exception to the rule. Kasi even though yung corporation sole, okay, di ba, under BP 68 na rin yan, na kasama sa RA 11232. But take note that, okay, exception to the rule siya. Because ang sole corporation magko-commence ang legal personality from the time of filing, not from the issuance of the certificate of incorporation by the SEC under its official seal. Tandaan nyo, hindi applicable ang section 18 sa foreign corporation, sa public corporation, government-owned and controlled corporation, as well as sole corporation. Okay, let us proceed now sa de facto. Sabi dito, the joint incorporation of any corporation claiming in good faith to be a corporation under this code. and its right to exercise corporate powers shall not be inquired into collaterally in any private suit to which such corporation may be a party. Such inquiry may be made by the Solicitor General in a quo warranto proceeding. Kaya mapapansin mo, based na sa definition pa lang ng Section 19 ngayon ng RA 11232 na dating Section 18 of BPC 68, actually wala naman changes doon sa content. Meron tayong tatlong essential requisite of de facto. Una, kailangan may valid law. Existence of valid statute. Ano ba yung tinutukoy kong existence ng valid statute? I'm referring to the general law, which is RA 11232 na ngayon. Kasi tandaan nyo, pag ang private corporation ay create under special laws, then such law is unconstitutional. Kung nare-recall yung diniscuss ko before dun sa Article 12, Section 16 of the 1987 Constitution, a private corporation can only be created through a general law. Kasi ang pwede lang i-create ng special law is only public corporation as well as government-owned and controlled corporation. Now, next. Okay, second, an attempt in good faith to form a corporation according to the requirement of law. Kasi di ba sabi ko sa inyo, ang de facto corporation kasi, nag-draft yan ng article. Sinubmit yan before the SEC at na-issuehan yan ng Certificate of Incorporation. Kasi tandaan nyo, pag wala kayong Certificate of Incorporation, kalimutan nyo na ang de facto. Hindi yan de facto corporation. That is a void or non-existing corporation. Now, meron na bang corporation by estoppel? I repeat, no. Kasi para magkaroon ng corporation by estoppel, dapat meron kayong dealing with third person on a corporate basis. Kaya hanggat wala kayong dealing with third person on a corporate basis, that is a mere association or group of person lang with no separate juridical personality. Pero the moment na itong group of person with no separate legal personality is now deal with third person on a corporate basis, makikreate yung tinatawag na corporation by estoppel. Okay? Now, ano ba yung concept ng de facto? Ang concept daw ng de facto corporation actually is a compromise between two conflicting public policy. Meron kasi ditong dalawang conflicting public policy na kailangang i-balance. First, yung tinatawag na unauthorized assumption of corporate powers. I-balance natin yan sa pangalawang public policy na favor of doing justice to the parties and of establishing a general assurance of security in business dealing. Ganito kasi yan. Di ba under theory of concession, a corporation exists because the state wants it to exist. And therefore, before a corporation can exercise corporate powers, they need to comply all or substantially all the requirements set forth by law. That's why if the corporation failed to comply all or substantially all the requirements set forth by law, when they exercise corporate powers, that is unauthorized. Kasi hindi nila kinumply lahat ng requirements set forth by law. Kaya once this corporation exercise corporate powers, that is unauthorized. At pwede ba siyang questionin ng state? Of course, the answer is yes. Kasi yung kanilang powers granted by the state. Pero i-balance daw natin yan sa another public policy na kailangan in every commercial dealing, dapat merong stability sa business transaction. Kasi just imagine, okay, kung walang stability ng business transaction, if any one of us can question the juridical personality of a de facto corporation, magkakaroon tayo ng unstable commercial transaction. Kaya para mabalance natin itong dalawa, pwedeng questionin bali lumalabas pwedeng questionin okay, yung separate juridical personality ng de facto corporation, pero para magkaroon ng stable commercial transaction, ang pwede lang mag-question sa separate juridical personality ng de facto corporation is only the state, through a direct proceeding initiated by the Solicitor General. O di na-balance na natin yung dalawang conflicting public policy. Pwedeng questionin, pero para stable ang commercial transaction, only the state can question the separate legal personality of this de facto. O di na-balance natin yung dalawang conflicting public policy. Now, ano may mga example of cases not precluding de facto? Una, defect in the execution of incorporation paper. Kaya kung hindi nyo nababa na-comply yung form prescribed by law, pero ang problema, na-issuehan kayo ng certificate of incorporation, then that is a de facto corporation. Another is corporate name violate the statute. Another is ineligibility of one or more incorporators. Kasi halimbawa, there are 5 incorporators before sa BP 68. Yung isa pala nun minor. Technically, there are only 4 na qualified. Ang problema, nakalusot, na-issuehan ng certificate of incorporation, then that is de facto. Nakita naman, walang de facto dito. Kailan naman walang de facto? Sabi dyan, entity formed under unconstitutional law. Kasi halimbawa yung private corporation create under special law. Di lumalabas yung law na nag-create doon sa private corporation is unconstitutional. Because it conflict under Article 12, Section 16 of the 1987 Constitution. Kaya since walang valid law na nag-create sa kanya, void siya. A non-existing corporation. Pangalawa, corporation form for purpose not permitted by law. Kasi halimbawa, yung corporation na inorganize is for the exercise of common profession. Di ba hindi yan permitted under the law? Dapat ang create ay general professional partnership. Failure to execute articles. Ibig sabihin, hindi ka nag-execute ng article. Or pwedeng nag-execute ka ng article of incorporation pero hindi nyo final sa SEC. Or pwedeng nag-execute ka ng article of incorporation, final mo sa SEC, pero hindi kayo na-issuehan ng certificate of incorporation. Kaya kung wala kayong certificate of incorporation, hindi yan de facto. That is a void or non-existing corporation. Pero the moment na may dealing na kayo sa third person on a corporate basis, then makikreate ang tinatawag na corporation by estopel. Okay, next. By the way, class exception to practice of profession in corporate form allowed sa practice of architecture, practice of interior design, saka practice of real estate services. Other than that, it should be a general professional partnership. 4 lang yung nakalagay dito ng exception ng architecture, interior design, real estate services, saka cross-town brokerage. Dapat it should be allowed by law. Otherwise, dapat GPP lang. Ngayon, ano bang pinagkaiba ng de jure and de facto corporation? Mapapansin mo sa de jure, since kinomply niya all or substantially all the requirements set forth by law, no one can attack the separate juridical personality of a de jure corporation. Walang pwedeng mag-question yan. Bakit? Kasi nga may compliance ng all or substantially all the requirements set forth by law. Kaya hindi pwede ang direct attack ng state, hindi pwedeng indirect attack ng state, hindi rin pwedeng direct or indirect attack ng private litigant. Pero pagdating sa de facto, pag direct attack ng state, pwede. Kasi pag sinabing direct attack, ang main issue ng case, they are questioning the authority of the corporation to exercise corporate powers. At yan yung main issue in a quo warranto proceeding. Pero indirect attack ng state, hindi pwede kasi mababiolate yung isang public policy na stability in business dealing. Hindi rin pwede ang direct or indirect attack ng private litigant. Kaya ang allowed lang is direct attack by the state through a direct proceeding called quo warranto, initiated by the Solicitor General. Okay. How about corporation by estopel? Sabi yan, all persons who assume to act as a corporation, knowing it to be without ito, alam nila, wala silang authority to do so, shall be liable as general partners. May na-notice ka ba? Meron siyang reference sa law on partnership. Okay? For all debts, liabilities, and damages incurred arising as a result thereof. Provided, however, that when any such ostensible corporation is sued on any transaction entered by it as a corporation or any torts committed by it as such, it shall not be allowed to use as defense its lack of corporate personality. Example class, halimbawa si ABCDE nag-organize ng X corporation. Nag-draft sila ng Article of Incorporation pero hindi nila na-submit before the Security and Exchange Commission. Anong effect? I-void sila. Walang X corporation. This is just a mere association of person or group of person lang with no separate juridical personality. Ngayon, meron na ba corporation by estapel? Wala pa. Pero ang problema, si ABCDE in behalf of X corporation, they transact with Y. Okay? Ginawa nila, they borrow 1 million. Saying that they are a corporation. Pinautang naman ni Y. Nung nag-mature, ayaw magbayad ni X corporation. Sabi ni ABCD, they are not liable because there is no corporation. Is that a defense? The answer is no. Kasi ang sinasabi dito, di ba, that when any such ostensible corporation is sued on any transaction entered by it as a corporation or any tort committed by it as such, it shall not be allowed to use as defense its lack of corporate personality. Kaya di na pwedeng gamitin defense na they are not liable because there is no corporation. E balik rin natin kung paano, what if si Y ang nagpautang kay X corporation? Ay X. Okay? Saying na sinasabi ni ABCD na merong X corporation. Nung nag-mature yung loan, of course, nung sinisingil ngayon for instance ni ABCDE, okay, si Y, in behalf of X corporation, sabi ni Y, hindi siya liable because wala naman palang corporation. Is that a good defense? No. Sasagutin naman niya ng second paragraph. Sabi niya, on was human obligation to an responsible corporation as such cannot resist performance thereof on the ground that there was in fact no corporation. Kaya ang basic rule is that kung ikaw ay naka-receive ng certain benefit from that ostensible corporation, you can no longer set up the defense that you are not liable because there is no corporation. Okay, mapapansin mo ito yung lumalabas na may reference sa law on partnership. Kaya lumalabas, di ba general rule ang corporation has limited liability because the stockholders are liable only to the extent of their shareholdings. Pero dito sa corporation by estoppel, may reference sa law on partnership wherein the members ng ostensible corporation is liable as general partners. That's why they are liable to the extent of their separate property. Ngayon, illustration. Okay, ABCDE attempted to incorporate X association but failed to comply one requirement of the law with knowledge of this failure to comply. Nevertheless, they assume to act as a corporation as a result of which they incur a 500,000 obligation from Y. Now, assuming the total asset of X association is 300,000, determine the liability of A, B, C, D, and E, and X association. Number 1, when it does not fall under 1822 and 1823 ng new civil code, not solidary. Kung nare-recall nyo sa law on partnership, ang liability ng partners is pro rata and subsidiary. Kaya lumalabas, kung kayo dito si Y, ang requires niya is ubusin niya yung asset ng X association na 300. Pag ubos na yung 200,000, i-divide mo ng 5. I-divide niya kay A, B, C, D, E pro rata. Okay? Number 2, when the circumstances fall under 1822 and 1823, solidary liability. Since solidary, pwedeng habulin dito ni Y, si X, pwedeng si A, si B, si C, si D, si E, or pwedeng some of them, or pwedeng all of them simultaneously as long as the debt is not fully collected. Number 3, assuming A, B, C, D, E agreed to distribute profit and loss at A 40% and 15% from each of B, C, D, E. Recourse ni Y, ubusin mo yung 300,000 na asset, yung 200,000, i-divide mo ng 5. Kaya 40, 40, 40, 40, 40. Pero magkakaroon sila ng private settlement. Kasi as between the partners, ang agreement nila, dapat si A ang share is 40% ng 200 which is 80. Tapos si B, C, D, E naman, dapat ang share nila 15% ng 200 which is 30 lang. Kaya since naging liable si A, B, C, D, E kay Y ng 40,000, dapat bayaran ni A, si B, C, D, E nung difference na 10,000. Number 4, assuming A, B, C, D agreed to distribute profit and losses based on capital contribution. A contributed 150,000 or 50% and the rest contributed 37.5 each or 12.5%. Okay, the remedy of Y is to exhaust first all the 300,000 and the balance of 200,000 will be divided equally between A, B, C, D, E. Kaya 40, 40, 40, 40, 40 ulit. Pero magkaroon ulit siya ng private settlement because in so far as A is concerned, dapat ang share niya sa 200,000 is 50%, which is 100,000. While B, C, D, E naman is 12.5% of 200,000 is 25,000. That's why A should pay B, C, D, E the difference of 15,000. Number 5, assuming A is an innocent passive associate o lumalabas parang dormant partner ka. Di ko nare-recall yung diniscuss sa loan partnership. Di ba sabi ko, pag dormant partner ka, liable ka sa existing partnership obligation pero isa-satisfy lang siya out of partnership asset. Kaya ang recourse ni Y, ubusin yung 300, yung balance na 200 divided by 4 lang. Hindi kasama si A. Okay? Kasi ang treatment sa kanya dyan, dormant partner siya. Innocent passive associate. Okay, ngayon, anong pinagkaiba ng de jure nga sa de facto? Una, sa de jure may substantial compliance but in de facto there is only colorable. Ulitin ko kaya siya tinawag na colorable compliance because the de facto corporation draft the article. Okay, they submit it before the SEC at na-issuehan din sila ng Certificate of Incorporation. Kasi sabi ko kung walang Certificate of Incorporation, it means there is no de facto corporation. Second, akin de jure, no one can attack the separate juridical personality of de jure. Samantalang pag de facto, pwedeng questionin ang kanyang separate juridical personality but only through a direct attack initiated by the Solicitor General. Next, pinagkaiba ng de facto versus corporation by estoppel. Ang de facto may real existence din kasi meron niyang corporate personality until questioned by the state through a direct proceeding called quo warranto. Samantalang ang corporation by estoppel, wala siyang real existence in law. But a mere friction existing only for a particular act. Second, ang de facto corporation pwede raw mag-exist even no dealing between the parties on a corporate basis. Sa corporation by estoppel naman, wala siyang real existence in law but a mere friction existing only for a particular act. Next, okay, sa de facto corporation, it may exist even no dealing between parties on a corporate basis. Pero sa corporation by estoppel, okay, it cannot exist unless there are dealing between parties on a corporate basis. Kasi di ba makabi ko, mandatory sa corporation by estoppel na dapat meron kayong dealing with third person na corporate basis. Kasi kung wala, walang corporation by estoppel. And last, sa de facto corporation, isa siyang less serious defective. Samantalang ang corporation by estoppel ay totally defective kasi wala siyang separate juridical personality. Okay, that's end my discussion. Okay, now, okay, next meeting naman. Okay, thank you and good night.